You ever make a deal where you and the other person were so sure you were talking about the same thing, only to find out later you had completely different ideas? Well, today we're diving into an incredible story about two companies, two contracts, and one very simple but surprisingly complicated word.
I mean, come on. What is chicken? Seems like a silly question, right? It's chicken. But what if a massive business deal, your company's entire reputation, and a landmark legal case all hinged on how you answer that one simple question?
Because that's exactly what happened back in 1957. And believe me, this story isn't really about poultry. It's a masterclass in why being crystal clear matters, and how a single, everyday word can mean two totally different things to two different people at the exact same time.
Okay, so let's set the scene. On one side, you've got Frigilement, a Swiss company, and they're really eager to buy some American chicken. On the other side is B&S, a seller from New York, who's kind of new to the whole international poultry game. They work out a deal, they sign the papers, and everything looks great. At first.
So check this out. These are the actual deals they signed on May 2nd, 1957. Two huge contracts for a boatload of U.S. fresh frozen chicken. They got all the details in there, weights, prices, the usual stuff. But the one little word that was about to blow this whole thing up was just sitting there, hiding in plain sight. Chicken.
So the first shipment arrives in Switzerland, and the folks at Frigilement are absolutely horrified. See, they were expecting young, tender birds you could broil or fry. But what they got were older, tougher stewing hens, what they called fowl. To them, chicken meant something very specific. But to B&S, chicken was just a broad catch-all term. And just like that, the fight was on.
The whole mess lands in front of the legendary Judge Friendly. And now it's his job to figure out what on earth these two parties actually agreed on. He basically had to become a linguistic detective, digging through the entire history of the deal, starting with the very first conversations they had.
Frigilement comes into court with a really clever argument. They say, look, we were talking about this deal in German sometimes, and the German word Huhn can mean either a young broiler or an old stewing hen. We deliberately use the English word chicken because we thought it only meant the young ones. Pretty smart angle, right?
But hold on. B&S remembered that exact conversation very differently. Their secretary gets on the stand and swears he specifically asked the buyer's agent, hey, what kind of chickens are we talking about here? And the answer he got back was any kind of chickens. He even followed up in German asking if they meant the broad term Hun and was told, yup. So suddenly that language clue got a whole lot murkier.
But this case wasn't just about what words mean. It was about cold, hard cash. And this number right here, 33 cents per pound, it turned out to be a huge piece of the puzzle. It was a major clue about what each side was really thinking.
And this chart, this was B&S's killer argument. See, at the time, young broilers, the kind Frigilement wanted, were selling on the market for around 36 cents a pound. The older stewing fowl, that was only about 30 cents. So B&S basically asked the judge, why in the world would we agree to sell something for 33 cents that costs us 36 cents to buy? It would mean they were literally signing a contract to lose money on every single bird. It just made zero business sense.
So, when a contract's words are fuzzy, courts often look at what's called trade usage. Basically, what does this word mean to the people who are in this business day in and day out? To figure that out, both sides brought in their heavy hitters, the expert witnesses.
Frigilament's experts were completely sure. One said flat out, in the poultry business, chicken means a broiler, full stop. Another backed him up. They even showed market reports where chicken and fowl were listed as two totally different things. You gotta admit, their case was looking pretty strong.
But then, the defense brought their experts to the stand. One of them had this fantastic, simple definition. Chicken is everything except a goose, a duck, and a turkey. Others said, yeah, chicken is just the general term we use for all of it. So what you ended up with was a total stalemate. The experts had completely canceled each other out.
And this is where Judge Friendly just shows his genius. He pointed out something brilliant. One of Frigilament's own star witnesses, a very successful, careful businessman, admitted on the stand that in his own contracts, he never ever just writes chicken. He always specifies broiler or fowl to avoid exactly this kind of mess. Basically, his actions screamed louder than his words in court.
All right, so the negotiations were a he said, she said, and the experts were a wash. Judge Friendly needed something solid, something objective that he could actually hang his hat on.
And he found it, tucked away right there in the contract's own fine print. You see, the contract said the product had to be Grade A, government inspected. B&S argued this meant the contract was tied to the Department of Agriculture's official definitions. So what did the government's own rulebook have to say? Well, right there, under the official heading of chickens, Section E, you'll find hen or stewing chicken or fowl. That was it. That was the smoking gun. The government itself considered fowl to be a class of chicken.
So, the picture was finally coming into focus. The judge had looked at the confusing negotiations, the very clear economics of the price, the dueling experts, and now this objective piece of evidence from the government. It was time to make the call.
And it all came down to this really important legal idea, the burden of proof. Because Frigilement was the one suing, it was their job to prove that their super-specific narrow definition of chicken was what both parties agreed to. B&S didn't have to prove their definition was the right one. Frigilement had to prove that theirs was the only one that could have been intended.
Judge Friendly really hammered this point home by quoting the great legal thinker Oliver Wendell Holmes Jr. Think about it. The law can't read your mind. It doesn't care what you were secretly hoping for. It cares about what you actually wrote down, what you actually said, what any reasonable person would understand from the words you chose to use. And so the final ruling came down. Frigigement had failed. They just couldn't prove that chicken was only meant in that narrow sense they wanted. Since the word could objectively include the older birds, backed up by the dictionary, government rules, and basic economics, B&S had not broken the contract. Case dismissed.
So, why are we still talking about a chicken deal from the 1950s? I mean, it's fascinating, but why does it matter? Because this case is taught in pretty much every law school for one timeless reason. It's a huge, unforgettable lesson about the absolute need to be clear.
And the takeaways here are so practical for all of us. First, always define your key terms. Don't just assume the other side knows what you're talking about. Second, be specific. So specific it almost feels silly. If you mean something specific, say that specific thing. And third, if there's any doubt at all, get clarification in writing. That one little email you sent today could save you from a massive legal headache tomorrow.
It really makes you stop and think, doesn't it? Think about all the common words you use every day in emails or texts. Words like soon, or reasonable, or finished. What little ambiguities are hiding in your own language, just waiting to turn into your very own modern-day case of the two chickens?